Hey guys, it's me again. And today I kind of just wanted to talk about the normativity of law. Um, and let me just explain what I mean by that. What I mean by the normativity of law, and by the way, this only applies to the really systems which work on precedent, which I believe are only the Anglo-American type legal systems, rather than like rhetoric and all of this other stuff that's present in other, especially Southern European legal systems. But yeah. Anyway, I wanted to talk about its normativity, and how that interacts with the notion of precedent in law. And what I mean by normativity is simply that that it's that a legal ruling or a sort of um legal concept is based on social norms, um rather than really any appeal to actual justice. And I'm not the first one that has pointed this out. This is another one of those things where Alexis de Tocqueville is just an absolute like genius in pointing that out in Democracy in America. But like, yeah, in Anglo-American legal systems we don't really argue about the real justice of a thing. We argue about its precedent, what people, I mean, we do, but only in light of the precedent, right? That's why you hear in articles, oh, this sets a dangerous precedent for so and so. And like, yeah, I have to say, especially early on in American legal cases, because I have had to discuss and debate and um sometimes write about um American legal cases like Dred Scott, like Plessy v. Ferguson, and all of these other things. And one thing that you realize is that um there is some appeal, right, to actual legal philosophy there. Like, um obviously, because it was such a new country, they didn't have that much precedent in the Supreme Court, so they would appeal to English authors like Blackstone and stuff like that. But you also see like a very normative, like, for example, in the Dred Scott decision, they straight up say, like, you know, black people since the beginning of society have been marked in this way, and that's why they don't deserve to be citizens and stuff like that. Um, which of course is wrong, but that's an entirely normative. Like, there's no reason for that other than just because his society accepted it. And of course, in the dissent, they're like, wait a minute though, like, free people, there were free people of color in the colonies, like, even before the revolution, and they were full British subjects, um without reservation. So it doesn't really make sense to say that, you know, Dred Scott wasn't one. And anyway, yeah. And so same thing for Plessy v. Ferguson, bro. They literally just made a normative claim, pretty much. Like, people have always known this, and that yes, we do want to protect people of color in like the before the courts and before the law and stuff like that, but that doesn't mean that you can change their unchangeable role in society, and so therefore separate train cars are permissible, right? Like, society and law are kind of different things, but are they really, is the question, because to me it doesn't seem like you can have one without the other, which is kind of connected to what I talked about before, which is like, if you want to live in society, in a society, yeah, I'm using that, but in the good way, like, you're going to have some sort of a system of obligations for all these different things. And that's what law does. That's why I've heard people say that like, law shouldn't legislate morality, and I'm like, what the heck? Like, literally every law legislates morality in some way. It has a moral dimension. There are very few laws that don't have a moral dimension some way down the line in the process of their enforcement. So what does that even mean? Anyway, yeah, especially in light of recent Supreme Court decisions, I thought that was it was good to sort of talk about this. Let me know what you guys think. I appreciate it. Have a nice day. Bye.